Sometimes we're asked whether or not there is a claim to be asserted if you're involved in an accident involving a piece of farming equipment. The answer is absolutely yes. For example, if you're injured in a crash involving a tractor on the road, a combine on the road, any sort of piece of farming equipment on the road, there very likely is the basis to pursue a claim, and there very likely is some sort of insurance policy, usually a commercial farming policy, or potentially an automobile policy, that would be triggered that would afford coverage for the acts of negligence on the part of the equipment user. Oftentimes, folks are also injured by farming equipment, whether that's working on a farm, whether it's a hobby farm or a family farm or whatever it might be. And we absolutely represent folks injured by farming equipment. Typically, those types of claims would fall under the product liability umbrella. Product liability is a very, very big umbrella that involves all sorts of different ins and outs of legal theories that can relate to the design of equipment and whether it's defective and dangerous, a piece of equipment that has itself a defect in it, a manufacturing flaw that causes an injury. It can involve improper warnings or lack of proper warnings that, if given, would have potentially prevented somebody from doing something that caused injuries. Warranties for property that have been breached, either a property or a piece of equipment doesn't do what the manufacturer says it's supposed to be able to do, or it fails in a way that it shouldn't fail. Those are all theories that exist in the context of a farming accident. And so we absolutely represent folks who are injured in those respects.